So this is a discussion about the non-duplication standard, which is part of OAL's review of rulemaking files. California's Office of Administrative Law, again the OAL, unless there's a statutory exemption, they're required to review rulemaking files that have been developed by an executive branch state agency or department when that agency adopts, amends, or repeals a regulation. And under California's Administrative Procedure Act, the APA, which is found in California's Government Code, there are six statutory standards that are used by OAL to evaluate regulations. These six statutory standards that OAL uses to evaluate regulations are necessity, authority, clarity, consistency, reference, and non duplication. Now, remember, OAL may not substitute its judgment for that of the rulemaking agency with regard to the substantive content of the regulation. Also, OAL has 30 working days in which to review the rulemaking record to determine whether it demonstrates that the rulemaking agency has satisfied the procedural requirements of California's APA. Let's take a closer look at the non duplication statutory standard. First, what is non-duplication? It basically means that a regulation does not serve the same purpose as a state or federal statute or another regulation. And as part of the APA process, California's OAL has adopted a number of regulations found in Title I of the California Code of Regulations, the CCR. So in Title I, 1 CCR Section 12, it's titled Non-Duplication. And Section 12 provides that a regulation must not serve the same purpose, as that term is used in Government Code Section 11349, Subdivision F, where it either repeats or rephrases in whole or in part a state or federal statute or regulation. Now, nonetheless, a regulation which duplicates a state or federal statute or existing regulation must meet the non-duplication standard of Government Code Section 11349.1 if any of the following three conditions are met. First, the proposed regulation duplicates or overlaps a state or federal statute or regulation, which is cited as authority or reference for the proposed regulation, and the duplication or overlap is necessary in order to satisfy the clarity standard. Second, the agency meets the requirement of Government Code Section 11346.9, Subdivision C, when adopting or amending federally mandated regulations. Or third, the duplication is mandated or it's authorized by a specified statute or other provision of law. So those are the main points of the non-duplication standard found under the APA, one of the six statutory standards of review used by OAL in evaluating and reviewing regulations.